For federal employees or applicants who want to appeal a discrimination case, the EEOC has just released a guide to help those that don't have lawyers navigate the appeals process and write better arguments. Edmund Chiang is the Senior Attorney Advisor at the Equal Employment Opportunity Commission. Edmund, welcome to the program.
Thank you very much for having me.
Okay, remind us of the process for when a government employee or an applicant wants to file a discrimination claim.
Okay, well, the process, to put it simply, if you are a federal employee or a job applicant and you feel a federal agency has discriminated against you, you first contact that particular federal agency. Afterwards, the agency will decide whether or not to accept your claim of discrimination. If they dismiss the claim, you can immediately appeal that decision to the EEOC Office of Federal Operations here in Washington, D.C.
Okay, which brings us to the appeal process. Okay,
Yeah.
So explain that process.
So the appeals process happens when there was a lower decision determining whether or not you were discriminated against or whether there's any other procedural defect. You can then file your appeal with EEOC and you can submit what we call an appeals brief. That's a statement in support of your appeal. And we will then consider both sides' arguments, look at the record, and issue an administrative appellate decision.
Okay, so give us some numbers about how many appeals decisions there are per year for federal employees or applicants, and then how many of those don't have a lawyer to help them.
Okay. Well, each fiscal year, our office receives between 4,000 to 5,000 appeals, and we roughly estimate between 70% to 80% of those appeals are done by people who don't have a lawyer. And among those people, about half don't submit appeal briefs at all.
What do you mean they don't? I mean, aren't they required to submit an appeals brief?
The appeals brief is an optional document, so some people, they do submit their briefs, but some people opt not to.
So what prompted the EEOC to put this guide together?
There's a couple strands, but I think what it really started was, we're always looking to try to improve our process to better serve our customers. And so a couple years ago, we did a focus group on people who had gone through that process. And what we learned was that there was this sort of hunger, this need for some additional guidance. One gentleman that I talked to, he had told us that he had spent hours and hours and hours trying to Google what the right format was to submit the appeal brief. He felt it was very important to look professional, to be correct, because that lent credibility. And there simply wasn't anything that he could access. So that was, I think, the first spark that prompted this project.
All right, well, take us through what the guide has. What are some of the important features?
Well, the guide itself attempts to demystify the legal fog that surrounds the appeals brief. So, for example, we have a glossary that explains what the legal jargon is, what the technical terms are. And also, I think more importantly, we have a section that tries to tell you what type of an appeal you have. And that, in turn, dictates what sort of things you should focus on in your appeals brief. And finally, we have, for that gentleman we talked to in the focus group, 2 sample briefs so that people can download them, look at them, and use them as templates going forward for their own appeals brief.
So what would you say is the biggest mistake people make when they're filing an appeals brief?
I think the biggest mistake is simply not knowing what type of appeal you have and what to focus on.
Yeah, explain that. What do you mean there's different types of appeals?
The basic types of appeals are between what we call procedural appeals and merits appeals. Procedural appeals are those where the previous decision dismissed your complaint because of a procedural defect. Either you failed to state a claim or you were untimely in some way. And a lot of folks, they focus on just the merits of their appeal. They're trying to prove discrimination when at that point in the process, it's not the relevant question they should focus on. For procedural decisions, you may have to show, yes, I was timely in contacting an EEO counselor. I was timely in filing my complaint. At that point, there has been no investigation. It's just not the right time to try to prove your case. And so I think if one takeaway people can get is just to distinguish between whether you have a procedural appeal or whether this is the moment where you have to prove discrimination.
The guide has just come out. I wonder what you're hoping will happen as a result of this guide being out and available and people using it.
Well, I hope that for federal employees and applicants who are representing themselves before the Commission, and also for those representatives who don't have legal training, so I'm talking about perhaps union representatives, they can have this guide to help them better understand what the appeals process is. And when they get a better understanding, they can understand what things that they should be focusing on in their briefs. They should then be able to make better arguments, we should be able to make better decisions, and ultimately they should have a better experience overall with the process.
And finally, Edmund, I know among the priorities of the administration is equity, accessibility, also better customer service for the American people. How does this further that?
Definitely for those who can't afford attorneys, this is a way for them not to level the playing field, but just to, give them a better chance to make their best arguments before us.
All right. Well, Edmund, thanks so much for being on the program.
Thank you very much, Mimi.